Deputy, you ready?
Yes, sir.
You got everybody ready?
Yes, sir.
All right. Good morning, ladies and gentlemen. My name is John Fry. I'm a judge here in the 17th Judicial Circuit. You're here for magistrate court. Magistrate court, or first appearance court as we often refer to it, as your first appearance in front of a judge. What's going to happen is I'm going to review documents. I'm going to establish, based upon the reports and information provided to me, whether or not there is probable cause to believe that you potentially committed these acts, which ones there's probable cause to believe you potentially committed. And if I do find probable cause to set the standards or conditions of release, assuming I'm statutorily allowed to do so, to one, ensure your liberty if it's appropriate, and two, do my best to ensure the safety of the public and your returning to court at a later date. I want to caution you, everything that you say is recorded. At least 10 of you sit in that room is going to want to try and sit down and explain to me why you didn't do something you're accused of doing. The dilemma is, in the process of you attempting to explain to me why you didn't do it, you're going to admit to at least 2/3 of what you're alleged to have done. Here's my example. Judge, I just didn't know my license was suspended when that police officer pulled me over. So what have you done? You've admitted it was you. You admitted you had contact with the police. You admitted you were driving the car. And then I have a report and pictures of you in other courthouses over the last 2 years that reflect that your license was suspended and you knew it. All of a sudden, the state of Florida wants you to go to prison, and you've admitted to everything. So I would highly suggest that you just keep your mouth shut, all right, and listen to what I have to say. You're more than willing to talk, or you're more than free to talk to me. All right, I'm not telling you not to talk to me. Please don't misunderstand me. If there's something you want me to know, feel free to let me know. All right, but I am cautioning you that it's not going to work out well if you start talking about your case. So having said that, let's go. We have a couple.
Judge, there's one up in the main jail, in the North Broward, that the deputies would like you to call for medical reasons on page.
North Broward.
Morning, Your Honor.
Good morning. What's the
Page
name?
7, Mr. Kenneth Hill.
Kenneth Hill. What's up, page 7? Okay. Okay, bye. Mr. Hill, you have a open capious warrant for your arrest in case number 173116MM10A. Your bond set in the amount of $500. Your next court date is set for August 7th. I believe that's next Monday at 11 in the morning. Good luck, young man.
Excuse me, sir, Your Honor.
Yes, sir.
Please says I just got off of life support 2 days ago.
Okay.
I have a heart condition and my seizures. Even this morning, I'm having a problem getting my medication here. I have to see the neurologist and the cardiologist and all kind. I just got off life support, sir. I was in a coma for a day and a half. My condition's gotten very worse since I got arrested that time. I've been in the hospital over 20 times. I'm sorry I missed that court date, but I've been in and out of the hospital, sir.
Sir, I'm going to release you on your own recognizance in this matter. We're going to let you out of Broward County Jail. I'll even ask the sheriff to give you a ride over to the hospital if you need one.
Yeah, I will,
All
sir,
right.
I will.
Hey, North Broward.
Yes, sir.
When y'all let him out, give him a ride over to the hospital for me, all right? That way you don't have to take him in the van and supervise him for the next 8 days. Have a good day. Bye-bye.
Thank you, sir.
Good luck, young man. Good luck. Keep fighting.
Yes, sir. Oh, thank you, God.
All right, so now let's go to Derek Ragunath.
Hi, Judge. Good morning. Sid Fleischman on behalf of Mr. Ragunath. Judge, what page is that on?
I don't know. I get stacks of paper. They don't write the pages on it. Page 7, pursuant to our esteemed colleague from the media.
17.
17, excuse me. Ma'am, are you some relationship with him? Would you like to come up and stand next to the attorney with me, or would you prefer to stay there? All right. So, counsel, my understanding, first of all, I'm reviewing the information. I do find probable cause. My understanding is that the state is amenable to a $17,000 bond and no victim contact. Is that correct?
That's correct. And the state will, we've broken it down per count, and the state will explain that to you.
Eric.
Your Honor, we've agreed to bonds in the amount of 1,000 on 1, 1,000 on 2, 3,000 on 3, 500 on 4, 500 on 5, 500 on 6, 500 on 7, 500 on 8 and 9, and 3,000 on the rest of the charges. In that order, no victim contact. Of the yes,
Right.
every exploitation is 3,000.
So the total is 17,000.
All right, so Mr. Ragnorath, I'm sorry, I probably mispronounced that. I apologize. All right, on count 1, grand theft, your bond's going to be set in the amount of $1,000. Count 2, past forged or altered bill, your bond's going to be set in the amount of $1,000. Exportation of an elderly in count 3, less than 20 grand, your bond's going to be $3,000. Count 4, 5, and 6, grand theft, $500 on each count. Count 7, 8, and 9, passing forged, altered bill, or promissory note, your bond's going to be $500 on each count. Counts 10, 11, and 12, exploitation of elderly less than $20,000, your bond's going to be $3,000 on each one of those. Your cumulative total bond is $17,000. Your attorney is a very competent and skilled attorney. I've seen him work. I've tried cases as co-counsel with him back in the day, a long time ago. I'm sure he vigorously fought for this amount, and it would have been exponentially more, but for the fact that he managed to get it down. Good work, counselor.
Thank you.
Have a good day.
Okay, thanks, Judge.
All right, Omar Batista. Omar Batista. Now, my understanding is there's family here for Omar?
That is correct, Your Honor.
All right. Hang on 1 second, guys. Oh, I'm sorry. All right, Mr. Batista, you're charged with 6 separate counts, 4 counts of burglary of an unoccupied conveyance, a dependency issue, and a petty theft in the first degree. In reading the reports, information, and documentation, have you all had a chance to see these documents yet? All right. What I'll do is I'll hand them over so you can read them when I'm done, just so you understand what I'm talking about. I'm going to ask you all a couple questions because I have some grave concerns here from what I've read. Again, no disrespect to you. Who are you to him, sir? You're his grandfather? Did you say grandfather? Pretty young to be a grandfather. All right, ma'am, who are you? All right, ma'am. You're his mother. Okay. I'm sure none of you anticipated being in this situation X amount of years ago. I'm very cognizant of that. I have 4 kids myself, and I have to be honest with you. My wife and I spend every waking moment trying to make sure that our kids don't go down the wrong path. I'm cognizant of all that, but by the time something comes to me, it's a little bit too late, at which point I have to do 2 things. The first thing I have to do overall is ensure that your son appears to have done what he's accused of doing. And I'm not saying he did it, but I am saying from what I've read, I do have a very good basis to believe he might have done it. The second thing that I have to do is I have to ensure the safety of the residents of Broward County from your son based upon what he's alleged to have done. And then the third thing I have to do, very frankly, is to protect your son's rights to a release on a reasonable bond. But a reasonable bond, in my mind, might not be a reasonable bond in you guys' eyes. So I have to somehow, over the course of about a minute, take the entire world history of this young man, put it into a set of facts, and come up with my best, most educated guess, because that's what it is, what I can do to protect the residents of Broward County and to ensure that your son, who's presumed innocent at this point, has a reasonable bond. So the first thing I'm going to do, I've already read the report, but I'm going to highlight a couple of the key points for you, okay? Can you mute that for me? And good morning. Can you mute?
Good morning, Judge.
Can you mute that for
yeah, I
me?
can,
Because
sure.
the background is ridiculous. Investigation revealed that the defendant, Omar Batista, and co-defendant Josiah Levy, knowing and intentionally gained entry into the victim's 2014 white Nissan Altima with a tag on it. Witness Agent Diaz, who is a federal government law enforcement officer, so there was a federal law enforcement witness to this, Witness Agent Diaz observed defendant Batista and co-defendant Levy inside the victim vehicle, rummaging through her belongings and within the vehicle compartments. Witness Agent Diaz, who is an Immigration and Customs Enforcement Border Patrol agent or some variation thereof, detained Batista and co-defendant Levy until the police arrived. Post Miranda, both defendant Batista and co-defendant Levy admitted to knowing and lawfully entering into the victim's vehicle. Defendant Batista also admitted that he enticed co-defendant Levy to assist him in entering the vehicle and to provide a lookout for him. That's where the juvenile charge comes in. Victim stated she did not know Batista or Levy, and she did not authorize permission to enter the vehicle, and she will prosecute. In the probable cause affidavit, it says the defendant did provide a confession admitting he entered the Melrose Point community and committed 50 to 70 automobile burglaries between July 26th and July 27th. The defendant did knowingly and intentionally enter the vehicle, and it goes on about that for a little bit. Was then found in possession of a checkbook when he was taken into custody of Pembroke Pines Police. The victim's vehicle was also stolen on the state, but the defendant denied knowledge that the vehicle was stolen. So there's a whole bunch of stuff going on here. Which causes me obviously some concern. That's 50 to 75 people whose vehicles have been broken into. I don't doubt they were broken into. The question becomes whether or not your son and grandson did it. And he apparently was caught breaking into one, and he admitted to the police that he had not only broken into that one and a whole bunch more, at which point I'm sure the police then went around and found a whole bunch of victims or got a whole bunch of phone calls from the police. There's bad news and there's more bad news. The first portion of the bad news is that this is not 50 to 75 burglaries I have in front of me. It appears to be 3 or 4. So there's probably a lot of additional stuff coming down the pike. Having said that, what's the prior criminal history on this young man, Eric? All right.
Also, Judge, he just graduated from high school. He just turned 19. He just turned 18. His plan is to attend Broward College and then hopefully go on to FSU or University of Florida, whichever the court would prefer.
I don't like either one of those schools. I really don't. I can tell you that my daughter just started at UF, and I've really come to dislike that school.
I understand that.
And they're paying for everything, too.
You know, it's a toughest situation. Obviously, he has very strong ties to the community. Obviously, there's a lot of people out there who care a lot about
I'm
him.
going to give him a reasonable monetary bond, but then I'm just going to lock him up at home.
Oh, that's fine.
All right. First of all, let me explain to you first of all, let me do the procedural portion, and then we'll talk. All right. You can unmute that now, counsel, if you like. All right, Mr. Batista, you're charged with 3 counts of an unarmed burglary. You're charged with 1 count of basically having a juvenile lookout participate in your crime spree, 1 count of petty theft, and actually a 4th count of a vehicle burglary. On each of the burglary counts, I'm going to set his bond at $500. It could be substantially more. That's going to be $2,000 total. I'm sure that as novices in this, you can find out how to post a bond. If you have the access to $2,000, you can literally go right next door to the jail and post the bond today. Hang on, we'll get to that. It's not that I'm cutting you off, I just can't hear you. All right, a long time ago, things used to blow up all around me, and I used to shoot guns, and my hearing's not as good as it should be. And you seem like a very soft-spoken woman, so I can't hear a thing you're saying. So what you can do is you can literally go right out this building, go down the street 50 yards, go into the jail, and post that $2,000 bond if you have that ability to do so. Was he living at home with you, Mom? All right. Does he need to go anywhere or do anything? Okay. Are you willing to take him to and from school? Oh, yes. Or your parents, I guess, or your in-laws? Okay. Because this is what I'm going to do. I'm going to put him on the highest level of home security detention. This is not juvenile detention. Your son's going to have an ankle monitor everywhere he goes. The only place I'm going to allow him to go is to school. All right? He's not going to church. Is he a church kid or not really? Okay, good. He's not starting now. All right. You're going to get his food. You're going to get everything he needs. So he can just go to and from school that he's registered to be in. And they're going to check him and to see his attorneys when he needs to go see his attorneys. Obviously, if there's a medical visit or something like that. But they're going to know he left the house at 8:15. They're going to see if he stopped at Starbucks for 15 minutes. And I am trusting you to assist me to keep your son out of jail. Because as soon as he wanders off, BSO is going to alert and he's going to go right back to jail. All right? Any objections to that?
I have no objection to that.
State?
no.
I'm going to put him out on $2,000 bond. His mother and his grandparents are here. He has no prior history. I'm going to put him on level 1 lockdown other than go to school. Is that satisfactory?
Yes, Your Honor.
Thank you very much. Count 3, I'm going to ROR. Count 5, I'm going to ROR. All right, Omar, listen.
Yes, Your Honor.
You need to listen to me for a minute.
Listening.
All right. I cannot, in the more stronger way, convey this without lacing it with profanity and physical threats. If you mess this up, you are going to be sitting in there no bond every single day. Your mother and your grandparents are here. They're destroyed because of this. Don't mess it up. Good luck. Oscar Andrew, Andreu, BSO, I apologize, but I have family here. Oscar Andrew.
Yes, Your Honor. I believe Mr. Andrews' sister is here.
All right. Brian, you waiving formal reading?
Oh, yes, absolutely. Thank you.
All right. All right, ma'am, is there anything? I like your shirt. Should I trust you? You're wearing a Trust Me t-shirt with a rattlesnake on it as you're getting ready to come up here and talk about your brother.
I thought that was right.
All right. I've seen some very interesting shirts that just really made me wonder if people knew where they were going during the course of the day when they appeared in front of me.
It was the decent one I had.
I've
today,
got
so-
you. I'm sorry to meet you guys like this. So, Oscar, the Office of the Public Defender is a fine law firm, is agreeing to waiving the formal charges and a reading thereof. I assume you're okay with that, sir?
Judge, I'll explain to him what the charges are.
Okay. Now, I'm going to go off the record for 1 minute. Any objection?
No, Your Honor.
We're going to be back on the record. I have found probable cause on the 15 counts that I have before me. Ma'am, what is it? You tell me your name.
Cynthia Andrew.
All right, Miss Andrew, is there anything that you want to tell me? Or you're just here for moral support?
I don't know what to tell you. I mean, I know my brother, and I know his daily living, and
Does your brother have a job?
yes, he does.
Where does he work?
He works at a hospital, a clinic, as a chef.
Hang on for 1 minute.
16 counts, yeah. Eric, here, I'll just let the judge know that there's a pending, because he's here on the methamphetamine and the paraphernalia.
Alright, so man, basically you're telling me your brother is in love with you and you're here for him. Is that an accurate summary?
He's been with me for years.
Okay. Young man, there are 15 identical counts in this. Your bond on each one of these charges is going to be $1,000 per count. That would make your total bond $15,000. If in fact you do bond out from jail, you are to surrender all computers. You are to surrender all non-Star Trek era flip phones, anything with a screen that you can look at. You're to surrender
I know usually when it's firearms, it's the local law enforcement. I understand. That's why, frankly, normally the order is that he's not to be in possession of any devices with internet access.
with them?
Yeah, he lives with me.
You got other family in the area?
That way,
Sidebar? On all of them. He imposed it himself. So I'm saying, like, he did it.
okay, well,
Yeah.
that's what it is.
Okay.
Do you understand what I'm telling you, sir?
Yeah, it's sidebar.
Sir, can you hear me?
Yes, Judge.
All right, sir, your bond set at $15,000. You're to surrender any phones or electronic devices in your possession to your sister. If you're caught with an electronic device or phone, we're going to revoke your pretrial release. Good luck.
Thank you.
Yeah, I want them on standard supervision.
Is there any way to lower that?
No,
Go right here.
not right now, there isn't.
Is there any?
If he doesn't post bond, then when he gets in front of a division judge, his attorney can ask to have his bond reduced. But no, in light of the charges, absolutely not.
Okay, thank you very much.
Not this far back.
I don't care. Devalle Victoria, Victoria Devalle. Victoria Devalle.
Main jail.
All right, Ms. Devalle, you have a second offense DUI. You have a DUI with a minor, suspended license, and a couple of traffic tickets, as well as an open container. As a result of your DUI arrest, you blew a .266 and a .25. You probably had to be medically cleared at the hospital. You were so intoxicated. In light of the information contained in this probable cause affidavit, as to count one, I raise your bond to $5,000. Count two, I'm going to leave your bond at $1,000. Count three, I'm going to release you on your own recognizance. 4 and 5 do not require a monetary bond. I'm also going to order no alcohol, no intoxicants of any kind. I'm going to place you on pretrial release, and you'll submit to weekly urine samples. Thank you and good luck. Standard. Lauren Phelps, Lauren Phelps. Ms. Phelps, good morning. You have three open traffic warrants. Each one's $250. You have court on August 14th at 1:30. You have three open warrants. One's a traffic charge, and one is two separate counts on a city ordinance misdemeanor. Good luck. Denasia Higgs, Denasia Higgs. Ms. Higgs, your bond set in the amount of $100, $100 on your 2017 felony charge. Good luck, young lady.
Thank you.
All right, Leslie Schoolcraft, Leslie
Thank you.
Schoolcraft. Ms. Schoolcraft, unfortunately, I have the burden to advise you in case number 173571 CF10A, there's no bond warrant for your arrest. You have court on August 7th. Good luck. Annie Taylor McGee, Annie Taylor McGee.
She bonded.
Bonded. Natalie Bryant, Natalie Bryant.
North Broward.
Ms. Bryant, you have three charges. One count of Ms. Bryant, you have three charges. One count of grand theft, one count of illegal use of a credit card more than $2,000, more than 2 times in 6 months for goods in excess of $100, and defrauding an innkeeper. I've read the report. I do find probable cause as to all the charges. As to count one, I set your bond in the amount of $1,000. As to count two, I set your bond in the amount of $1,000. As to count three, I set your bond in the amount of $25. Good luck, young lady.
Thank you.
Portia White, Portia White.
North Broward.
Morning, Miss White. All right, Miss White, you're charged with possession of cocaine. I do find probable cause. Drug paraphernalia, I do find probable cause. Driving on a suspended license, I do find probable cause. Count one, the possession of cocaine. Your bond set in the amount of $1,000. I'm going to ROR you on count two and count three. I do have the burden or obligation to advise you you're on a no bond warrant or hold from 2015 felony case. Good luck.
Your Honor, a Spanish interpreter is present.
Buenos dias. Robert, are you two here for a case? Yes, Judge. All right. Hang on one second. Let me do Spanish. All right, Madam Interpreter, you promised to translate from English to Spanish to Spanish to English to English to Spanish to Spanish to English to the best of your abilities.
I do.
Tell me
Maria
your-
Salazar, certified court interpreter.
All right, so who do we have that speaks Spanish? Other than you and me sometimes. Alguien quien solamente habla español. Solo español.
What's your name?
You were raised in New York of Hispanic heritage and fluent in English. That doesn't mean you go to the head of the line.
Page 9, Mr. Cordona.
Mr. Cordona, good morning to you, sir.
Buenos días, señor Cordona.
Buenos días.
Good morning.
Mr. Cardona Morales, yes?
Es el señor Cardona Morales. Yes.
All right, Mr. Cardona Morales, you are charged with DUI,
Señor Cardona Morales se le acusa de manejar bajo la influencia,
a juvenile in the car,
teniendo a una persona menor de edad en el carro,
reckless driving,
manejo temerario.
No, yo andaba solo.
I was just driving by myself in the car.
State, why is he charged? Oh, no, excuse me. You were charged with DUI above a .15. My mistake.
Señor, un error. Se le acusa de manejar bajo la influencia con un nivel de sangre, de alcohol en la sangre, perdón, de .15.
And Mr. Cardona Morales, you seem like an honest fellow to me.
Señor Cardona Morales, me parece que usted es una persona honesta,
Because when you were stopped by the police officer and he asked you to do roadsides,
porque cuando lo paró la policía y le pidieron que hiciera los ejercicios de campo,
you said, you know I'm drunk.
les contestó que ellos sabían de que usted estaba embriagado.
I know I'm drunk.
Yo sé que estoy embriagado, les dijo.
You got me, so there's no reason to do the test.
Ya me arrestaron, entonces no hay necesidad de que yo haga los ejercicios.
In light of that information,
En vista de esa información,
I don't really think you're a threat to society other than the whole DUI thing.
yo no pienso de que usted sea una amenaza para el público, aparte de ese cargo de manejar bajo la influencia.
And so I don't find you to be a flight risk.
Entonces, no lo encuentro a usted como un posible riesgo de irse del país.
Count one, that's the DUI, your bond's $500.
$500 para el cargo de DUI.
Count two, I'm going to reduce your bond to $500.
En el segundo cargo le voy a reducir la cantidad de fianza a $500.
And I'm going to release you on your own recognizance on any of the other criminal charges.
Y por los otros cargos penales que usted tiene, le voy a dar la libertad bajo palabra.
Good luck to you, young man. Buena suerte.
Que tenga buena suerte, señor.
Gracias.
Thank you.
All right, could you make an announcement? Anybody else who speaks only Spanish?
Yes, sir. La intérprete quiere saber si hay alguien más que habla español.
Y solamente español.
Solamente español.
None in Maine.
All right, ma'am, I'm sure I'll see you later on today.
Yes, sir.
All right, so Robert, what was the name of these good folks here? The defendant's name?
Mr. Akins on page 12.
All right.
I know the family would like a word with the court.
Ma'am, you can come too if you want. It's up to you. I'm sure this is somebody that matters to you since you're here. Akins. Hang on, let me find Akins.
Mr. Akins declined the PD.
Thank you. I addressed this case yesterday as well, didn't I? Akins, this is, yes,
Mind if I say something first?
absolutely.
Okay. First of all, I want to thank you for your time.
What is your name?
My name's Darren Akins. I'm Dylan's father. I want to
Mr.
thank you for
Akins.
your time and the court's time. Dylan just turned 19, and the issue here is I felt that he was a big enough man to go do this himself and turn himself in, which he did. He turned himself into the police for this situation. So I assumed everything was going to be okay because he did that. Not interfering or letting him become a man and deal with this situation himself. And he did, and then I find out that all this other stuff is happening. You got a bond, you put a bracelet, you want a bracelet. So we don't have a lawyer yet, and I feel he needs an opportunity to be able to say what he has to say and defend himself also. But I wanted him to try to do it. When I found out what happened, I went to the bail bond last night and bailed him. And then I found there was something else happening, which we're here today. So that's why I'm here, because I would love.
Can I ask you a couple questions?
Sure.
And I don't mean to interrupt you, just I know what I want to know, and I'm sure what you want to tell me might be different, and it's not appropriate today. I promise you there'll be a time where it's appropriate. It's just, as you can see from the camera, I have more people than when I went home last night. My wife looks at me and she's like, I don't know how you can do snapshots on human beings in 20 seconds and decide their incarceration. What was his bond at?
2,000.
Okay, and he was placed on GPS, correct?
Correct.
That sounds like something I would have done in that situation. State, we have an ad charge, or is it a change of charge?
It's an ad charge, Your Honor.
All right. Is there a feeling in the state of Florida that an additional monetary bond is necessary in light of the fact I'm already putting him on GPS?
Your Honor, the state does feel it is because Your Honor took into consideration, and you were provided with a copy of the facts, but Your Honor could only set a bond on the charge that was before the court yesterday, which was retaliating against a witness, or in that case, a victim.
This was the alleged situation where he said snitches get more than stitches. Okay, I remember that off the top of my head. That's generally not a good sign. Go ahead.
And then, as the court's aware, the allegation is that he and a co-defendant essentially jumped the victim, robbing him.
Got it.
So I do think.
But I knew about that charge yesterday. I remember us having that discussion.
I understand, but still, at the same time, the court was only in a position to set a bond on the charge that was before the court. Now, what's before the court is a charge where there's not just taking property from another, but an act of violence in doing so. And I do think some bond is appropriate.
Okay. Couple questions for you, Dad.
Sure.
All right, and if you could just answer my question. Does he live with you?
Yes, sir.
Is she the mother?
Yes, sir.
Are you two an intact family unit?
We hope to be we hope to be. That's why this is all.
I got 4 of them. I
Yeah.
understand your dilemma.
28 years.
Eric, you can wander over here and listen to this chat if you want.
Dylan,
Yes, sir.
can you hear me?
Yes, sir.
Turn around and look at all your new friends. You want to hang out with them?
No, sir.
You want to stay there, make new close personal friends?
No, sir.
So here's the deal. Your parents apparently love you. Your parents apparently are very concerned about you. And your parents are willing to do whatever they need to do to supervise you. Do you understand what I'm saying? Over the state's objection on count 2, I'm going to release him on his own recognizance in conjunction with count 1. Is he on level 2 or level 1 GPS? He doesn't have a job from what I remember. Is that correct?
No.
That's the lower one, right? Yes, it is. State, in order to ameliorate your concerns for a monetary bond and in order to keep your son out of trouble, I'm going to place him on level 1 house arrest. Level 1 house arrest means he's not going anywhere. He's not doing anything. He can go to school and doctors and to see his lawyer.
So we'll make the special condition, because level 1 usually doesn't even allow you to go to school.
Yeah, no, school, doctors, and lawyers, that's it, with pre-approval unless he's going to county general. All right, other than that, he's not leaving the house. You are now his Uber driver, Uber Eats, and the whole 9 yards. All right, he's not leaving home for any reason. Dylan, you wander away, you don't charge your GPS, you don't do anything you're told to do, you're going to be hanging out with your new best buds. Do you understand me? In addition to that, I'm authorizing your father and your mother the ability to tell you to do anything in that house that they want to. If they were to reach a decision that you're not in compliance with their request, they're to notify the state attorney's office, at which point we'll violate your pretrial release. So do you understand me?
Yes, sir.
So when I tell my kids to do something, there's like this pregnant pause whether they think whether or not they're going to do what I say. They do a cost-benefit analysis on whether or not they should do it or whether or not they want me to light them up. You understand what I'm saying? You shouldn't even be doing that cost-benefit analysis because you're going to be back in jail. I don't want to see you again. Go away. Bye-bye. All right, 1 second, off the record. In addition to Mr. McLaurin.
In addition to Mr. McLawrence.
Ma'am, what case are you on? Good morning.
So page 26, very close to the end of the docket, Judge.
What, who, where?
Leslie Boudoir.
Very close to the end.
Got it. All right, out of turn, we have counsel present. We're going to call Leslie Sherlock Boudoir. Give me 1 minute, counsel. I haven't read this yet.
Sure, no problem.
All right, as to, there are 3 counts in this probable cause affidavit, or 3 charges being filed. One is abused child without great bodily harm. One is possession of weapon or ammunition by a convicted felon. And the third is carrying a concealed firearm. Counsel, what would you like me to know?
Your Honor, as far as his priors, I don't have a full list, but I don't believe that he has any other, any violent priors. He does have the prior felony conviction, but it's for DWLS.
Hang on for 1 second. Let's find him.
Sure.
Where's Mr. Boudoir? Leslie Boudoir. Anybody know?
Judge, I'm looking for him on the docket just so I can see what jail he's at.
Very
I
back,
think
like
he's at the
26.
Main jail, Your Honor.
he should be at the main jail. Leslie Boudoir, sir. If Jara was over there, he'd have him already up there at the podium. That's not him. Main jail, you got any Leslie Boudoirs there?
What it is, Judge, he's probably, we were overfilled this morning. There's a few people in the back. He's probably back there. I'll have him run, go grab him.
All right, have him grab him and then bring him right back up when he's done. All right, we'll get as quick as we
Great,
can.
thank you.
Jara, what do you have? Good morning.
Good morning, Judge. Judge, I have 3 in the main jail that we could probably,
Help clear out.
yes, Your Honor.
Here he is, Judge.
All right, Mr. Boudoir is here. All right, Mr. Boudoir, your attorney is here. I've just read the charges against you. One is abusing a child without great bodily harm. Second is possession of a weapon or ammunition by a convicted felon. And third is carrying a concealed firearm. Ma'am, what would you like me to know?
And Your Honor, I believe his priors are mainly nonviolent. He does have the DWLS habitual prior conviction. He does have pending child support and paternity case pending that we're working on. And Your Honor, he's not a flight risk. He has retained counsel. He has family in South Florida. Even though he's not employed at this time, he
Can I say something?
Hang on one second. Your attorney's doing a really good job for you, so let her keep going.
Your Honor, he is longtime resident of South Florida. He does have family here. He does not have a history of missing court. I am asking for a standard bond.
State.
The state just wants to make you aware that there, Eileen Reese, for the state, Your Honor. The state just wants to make you aware that there is an open cruelty to animals case. Mr. Boudoir has not been served yet. There's also possession of cocaine, violation of probation. And that's it.
So is the possession of cocaine case open?
No, Your Honor. He was put on probation. Well, yes, he's put on probation. Seems like this would violate. I'm sorry. No, it would. It is not open.
Thank you, counsel. All right, so Mr. Boudoir, counsel, the child in question, does he live with the child, if you know? Don't help, Mr. Boudoir.
I don't believe so. I'm
All
not
right.
positive offhand.
Would you object to me asking that question whether or not, and I don't really think that it's going to violate his rights since the child is him junior, whether or not he knows who his child is. Do you know who your child is, sir?
Yes, sir. I raised him ever since he was born.
All right.
Lived with me all my life.
Does he live with you now?
No, sir. Me and my wife is going through a separation.
Okay. I need to explain something to you. If I let you out, you're not to have any contact with him unless or until after the family court judge makes a determination knowing about this case that you may do so. So when you walk out of jail today, you're not to talk to him, you're not to interact with him, you're not to interact with your wife about him, you're not to pass any messages to him, because that's not going to end well for you. Do you understand?
Yes, sir.
All right, as to count 1, court does find probable cause. Court's going to order a bond in that case in the amount of $1,500. That $1,500 will include no victim contact of any kind. Count 2, I'm going to release him on his own recognizance. Count 3, I'm going to release him on his own recognizance. Based upon your attorney's strong arguments, your bond is only going to be $1,500. It was going to be much more about 5 minutes ago. Have a good day. Good luck.
Thank you, Your Honor. You're welcome. Great to see you.
Jar, top of the morning. What can I do for the great city of Fort Lauderdale?
Judge, at the beginning of your docket, there's a Lauren Phelps. She's over in North Broward.
Lauren Phelps. Lauren Phelps.
She's in North Broward, Judge.
Your Honor, you've already seen her.
I've already seen her, Jar. What'd I do?
Judge, what I was going to inform the court is that the city and the state have already made offers on Ms. Phelps' case when she appeared before Judge Levy, and I wanted to relay those offers to you in the hopes that we could resolve her case this morning.
Are you going to be back here this afternoon or no?
I could be, Judge, if you want me back here
Well,
this afternoon.
I don't want to inconvenience you, but I got like 100 people sitting there.
Well, I just want you to know that on her case, the city offered her withholding costs And on the state case, the state also offered her withholding costs, Judge.
All right, let's get her back. I'll do the whole colloquy and all the information. I'm going to point you on this case.
I'm already appointed on the case, Judge.
Okay.
She's in North Broward. I don't know.
North Broward, if you can find her, I'll be with her in about half an hour after I can at least get through 40 or 50 more cases. What's the next one, Jar?
On page 8 of the docket, there is a Daniel Steckel. He's over in the main jail.
Did we do that one already? Daniel Stecco at the main jail. Got it.
Judge, count 1 is a state misdemeanor trespass, and count 2 is the municipal ordinance alcoholic beverage, Your Honor.
All right, what do you want to do?
Judge, I would be asking if the court would be inclined to resolve these cases for Mr. Steckel.
Mr. Stecco, you want to resolve these cases today?
Yes, Your Honor.
All right. State, what's his priors?
792186.
Anything recent that should cause me some angst? All right, on Demetrius Lightfoot, the attorney apparently contacted my JA, asked us to roll it to this afternoon. All right, so what were you saying, Eric?
Nothing too recent.
All right, Mr. Stecco, you understand if you're not a citizen of my beloved United States of America, the entry of this plea is going to result in your deportation? Yes or no?
Yes.
You understand that if you're on probation, parole, anything that nature, anywhere on planet Earth, the entry of this plea is going to violate that probation or parole?
Yes.
You understand that President is Jar McLawrence. Jar McLawrence is licensed attorney in the great state of Florida. He has been hired by the city of Fort Lauderdale to represent their indigent defendants. He's their public defender. He's a very good attorney. They're very lucky to have him. He stands ready to assist you and fight this case to the end for you. Are you telling him you don't want him to do that? You just want to resolve this case and get out of jail today? Is that correct?
Yes.
And is it the same for the state charge as well? The current charge you have, the trespassing. You want to resolve that today?
Yes.
All right, you understand that at no time, in no way, shape, or form are you to go back to Island Park Preserve in the beautiful city of Wilton Manors. Do you understand that?
Yes.
You still want to resolve this case today?
Yes.
You understand this case will be used against you, both these cases will be used against you if you have any further criminal conduct down the road. It will result in an enhanced prison sentence potentially. You understand that?
Yes.
How do you plead on both cases? Guilty, not guilty, or no contest?
No contest.
All right, is that on both cases?
Yes, sir.
Withhold court costs, both cases. Good luck. What's the next one? Jar?
Judge, the next one is Willie Grayson on page 10 of the docket.
Take care, sir.
He's also in the main jail.
Willie Grayson. Willie Grayson. Did we already do that one?
Judge, he's here on a municipal ordinance trespass matter.
Hello, Mr. Grayson.
Hello, sir.
How are you today?
All right, how about you?
All right. Did they feed you?
Yes, sir.
What'd they give you this morning?
Egg and bacon and grits.
Ooh.
Boiled egg.
Was it good?
Can't complain.
All right. So you were allegedly in front of Il Molino's in Canyon, restaurants on Sunrise Boulevard. Robert and I go there for lunch. They have a great chicken sandwich, by the way. All right. Could you stop hanging out there?
Yes, sir.
go find a different place because Fort Lauderdale is going to arrest you for trespassing there. And they always go in there to eat too. All right?
Y'all don't worry about me no more.
All right. Jared, he want to resolve it?
Yes, Judge.
Yes, I do, Your Honor.
All right. Are you on probation, parole, anything of that nature anywhere on planet Earth?
No.
You understand that President is Jar McLawrence. Mr. Lawrence is the public defender for the great city of Fort Lauderdale. He's ready to try this case for you. Go in and fight it. We might even be able to arrange a food trip over there. Go have lunch and see whether or not the food's any good as part of the trial. You want to resolve this case and deny us that ability to go have a good lunch?
Yes, Your Honor.
All right. Sir, this is not the end of the world. We're not solving Jimmy Hoffa's murder, but I do need you to stay away from there, okay?
I will, Your Honor.
All right. How do you plead?
No contest.
Withholding court costs. Good luck to you, young man. I hope things get better for you.
All right, thank you, Your Honor.
Take care. Bye-bye.
Judge,
What else you got?
Lastly,
What?
was someone saying something?
Yes, Judge Wright. North Broward.
Okay.
We have Miss Barn Phelps.
All right. We'll be back with her in a minute. What was the other one?
Judge, lastly, also in the main jail, there's John Abrams. He should be right after Mr. Willie Grayson. John Abrams? He's here on a possession of controlled substance
Got it.
and a possession of paraphernalia.
Mr. Abrams, good morning to you, sir.
Well, sir.
All right. You're here on 2 municipal warrant charges. What are they, Jar?
Possession of controlled substance, which is more than likely marijuana, and possession of paraphernalia.
You want to resolve those?
Yes, Judge.
All right, Mr. Abrams, do you want to resolve these two cases, or do you want to post $1,000 bond, get out, and fight them?
I'd just rather resolve them, sir.
Is anybody making you do that?
Say, no, sir.
All right, Mr. McLawrence is here for you as well. He stands ready to investigate, review, go over the documents, take depositions, speak to witnesses, do everything you ever seen on TV. And if you resolve this case, you're telling him not to do any of that. You understand that?
Yes, sir.
Anybody threatening or forcing you, making you do this today?
No, sir.
You understand, if you're not a citizen of my beloved United States of America, the answer to this plea is going to result in your deportation?
Yes, sir.
All right, you understand the criminal score sheet. If you're on probation, parole, anything of that nature, the answer to this plea is going to violate probation or parole. You understand that?
Yes, sir.
All right, you also understand you commit a criminal offense in the future, points are going to be assessed as a result of these pleas today, which could result in an enhanced state prison sentence. Do you understand that?
Yes, sir.
Or even a federal sentence. All right, you understand all that?
Yes, sir.
You still want to resolve this case, or these two counts in this one case?
Yeah, I just want to get it over with.
How do you plead?
No contest.
Withholding court cost on one, withholding waive on two. All right, so the other person was for you, Jar?
Yes, Judge. Lauren Phelps, and she's
Can we
over in
pull
North
up Miss
Broward.
Phelps again? Do you have that?
Judge, the first two counts are the municipal ordinance counts. The third count is a state misdemeanor, and she's represented by George Odom. He called me this morning, or contacted me this morning, and asked me to cover for him on his behalf. And this matter was just in front of Judge Levy, I want to say last week. And at that time, the state and the city offered her withholding costs to resolve this case.
And is her attorney in the private case willing to do that?
Yes, Judge.
All right, ma'am. I have Mr. McLawrence here from the city of Fort Lauderdale. He's advising me that he, in conjunction with your private attorney, have had discussions with the state of Florida, and that the state is willing to offer you a withholding court cost on all your counts. Do you understand that?
Yes.
Do you want to take that, or do you want to fight it?
Yes.
All right, this called for a decision. Do you want to take the state's offer, or do you want to fight it?
I want to take the offer.
All right, anybody threatening or forcing you, making you do this today?
No.
You understand you have not one but two separate attorneys who are willing to be the Broward version of the dream team and fight this to the end for you, and you're saying you don't want to do any of that, you just want to resolve this case. Is that correct?
No. No. I'm not sure.
Judge, maybe I should call her.
All right, Mr. McLawrence is going to call you right now on the phone and talk to you. That's your attorney, all right?
Okay.
Yes, thank you, Judge.
All right. BSO, he's going to reach out to her. You can hold on to her until we get to there. All right, back on the docket finally. Emily Colazzo.
North Broward.
All right. Ms. Colazzo, I reviewed the probable cause affidavit. I do find probable cause. Apparently, allegedly, when you had a suspended license that you knew about, you managed to get in an accident, you then fled on foot from the scene of the accident, only to be caught later. Count 1, that's failure to stop or remain in an accident. I'm going to set your bond in the amount of $1,000. Operating without a valid license, I'm going to ROR you. Driving on a suspended license, I'm going to ROR you. And count 4 is an infraction. There's no bond. Your bond set at $1,000. Good luck, young lady. Amanda Sutton. Amanda Sutton. Ms. Sutton, I reviewed your paperwork. You're charged with 1 count of battery on a law enforcement officer, disorderly conduct, brawling, and fight. As to count 1, I set your bond in the amount of $1,000. As to count 2, I release you on your own recognizance. Good luck, young lady.
Your Honor, I'm going to be asking the court to sign a photo order.
I'll grant that order. All right. Rogetta Donnell.
Main jail.
All right, Ms. Donnell, you have a misuse of a temporary tag. Your bond's going to be set at $100 on that count. You haven't engaged in public fraud or disuse. Your bond's set at $1,000. So your total bond's $1,100. Good luck, young lady. Naisha Jackson.
She's on her way up, Judge. She indicated she's going to represent herself.
Oh, okay. Hello.
Hello.
How are you today?
I'm okay.
All right, you're charged with driving on a suspended license, third or subsequent offense, and an equipment violation. Do you understand that?
Yes.
All right, your bond set in the amount of $750. Good luck, young lady.
All right. Thank you.
You're welcome. Jonathan Owens.
Main jail.
Mr. Owens, you're charged with exposure of sexual organs in public. Your bond set in the amount of $1,000. Good luck, young man. Travis Shelton.
Conti.
Your Honor, he's in courtroom 6750 this morning.
Outstanding. Maybe they're going to serve him with his $250 capias.
Okay.
All right. Jar, are we going to go back on this case?
Yes, Judge. Lauren Phelps over in North Broward.
North Broward, Phelps.
I wanted to plead no contest.
All right. You had a chance to talk to your attorney?
Yes.
All right. You understand all your rights as I explained them to you?
Yes, sir.
How do you plead?
No contest.
All right. Withhold and waive on the state charge. Withhold and court costs on the city charge.
Yes, and Ms. Phelps, you need to go ahead and give your mom a call.
Okay.
Just go ahead and call her when you get out so she has your number, okay?
Okay.
Call your mom. All right. Moms like it when you call them, all right?
I know she's gonna love it.
Especially when they find out what you're sitting in jail and then they really want to talk to you. Good luck.
Thank you.
Bye-bye.
All right. Thank you, sir.
Take care, young lady. Audlin Orban.
Conti?
Conte. Hang on one second. I'm increasing it to 1,000. That's the guy in the jail that decided he was going to blow off what BSO told him to do? Oh, yeah, no, we're 10 timing his bond. It's going to be $1,000. All right, they don't deserve that. Audlin Orban. Mr. Orban, good morning.
Good morning, sir.
You have an active traffic warrant. Your bond set in the amount of $250.
Sir, I was in custody when that happened, so I couldn't make it on court on the 27th. I was here.
All right.
He also has been county sentenced on a DUI, Judge. This count 2 is the only count he has left.
Does he want to resolve this
Do you
one?
want to resolve this, Mr. Auburn?
How could we resolve it today?
How much time you got left in county jail?
To Friday.
Friday?
Yes.
Today's what, Wednesday? Yes. How long you been in jail?
Since the 17th.
Now I got to do math. It's what, like 2 weeks? You resolve it today, I am going to adjudicate you guilty. What's he charged with?
Operating without a license.
I'm going to adjudicate you guilty of operating a motor vehicle without a license. I'm going to remand you to the custody of the sheriff of Broward County for 10 days with credit for 15 days.
It's time served.
Yes. Yes.
You want to take that deal?
Yes, Your Honor.
Anybody threaten or forcing you make you take that deal?
No, Your Honor.
How do you plead?
No contest.
Good luck, young man. Take care.
You too. Take care, Judge. Have a good one.
Bye-bye. Sammy Dix.
Yes, sir.
Hey, Jim. Judge, Mr. Dix wanted to know if the court would be able to work this out for him. His son's down from Tampa visiting, and he'd like to try and get out and see him.
State, is this, will you pull up his driving history? Mr. Dix, I'm going to ask you to sit down. We can probably work through this. I just need you to stay there for a little bit, all right? All right. Oh, hang on. Mr. Dix, come on back up here. Apparently, they're going to have it right now. Never mind. I have it right now.
Okay, good.
Oh, thank you. This is going to be his third D. No, it might not be. Yeah, it is going to be. No, it might not be. Yeah, it is going to be. This is going to be his third suspended license within 5.
If I can have a second judge to explain to him.
Okay.
Cool.
He has one from 2012, one from 2016. It's going to be his second. Hey, it's going to be his second, not his third. He beat the timer on the 2012 one.
Yeah, because I paid for my license 2007.
I'll explain it, Judge.
Explain to him that if he wants to resolve it, it's a withholding court case. Huh?
He's not gonna be that close to the 5 years for that third one.
No, oh no.
I've explained it, Judge. He wishes to accept the offer.
All right, let me make sure we're on the same page. On June 16, 2016, you entered a plea to suspended license. Do you understand what I'm saying?
Yes.
All right, now you're going to enter a plea to another one today. That'll be 2. So that means that until June 15th of 2021, unless we change the law, you pick up another one, you're going to lose your license for 5 years. Do you understand that?
Yes, sir.
You still want to resolve your case today?
Yes, because I'm going to get them resolved after my son leave to go back to Tampa.
Okay. You understand if you're on probation, parole, anything of that nature, the entry to this plea violated?
I'm not on nothing.
Anybody threatening or forcing you, making you do this today?
Say that again?
Anybody threatening you, forcing you,
No,
making
no,
you
sir.
do this today?
No,
All right.
sir.
You think it's in your best interest to do this?
Yes.
You understand if you're not a citizen of the United States of America, the entry of this plea will result in your deportation?
Yes, sir.
You understand that if you couldn't afford an attorney, I'd appoint one to represent you?
Yes, sir.
All right, our public defenders are good. They come up with stuff I don't even understand. You're saying you don't want them to do any of that stuff? You just want to be done with it?
Yes.
How do you plead?
No contest, sir.
Withholding court cost on count 1 of any additional charges. Withholding waive on any additional charges. You'll be out in like 8 hours.
I appreciate it.
You're welcome. Richard Knox. Richard Knox.
Yes, sir.
All right, Mr. Knox, you are charged with trespassing. Do you understand that?
Yes, sir.
Your bond set in the $100. Good luck, young man. Francisco Carballo Matos. All right, Mr. Matos, you have 3 active capiases, 2 $750, 1 $500. Your total bond's $2,000. You'll be in court in 2 days at 9 in the morning. Good luck. Preston Sabat. Preston Sabat. Mr. Sabat, you're charged with driving on a suspended license. There's also what appears to be a child support writ. Suspended license, $100. Child support writ appears to be $603 or $608. Good luck to you, young man.
Yes, sir.
Akeem Carter. Akeem Carter.
North Broward.
Akeem, good morning. The capias for your arrest, $100 bond. Good luck. Donovan Mosley.
Main Joe.
Yes, sir.
Mr. Mosley, you have 2 separate traffic criminal cases from one of the satellite courts where you have warrants out. $500 your total bond. Good luck.
Sir, can I ask you a question?
Sure you can.
I have a
Be
roommate
careful.
right now.
Be careful.
Yes, sir. Is there any way I can get an RR?
Why?
I have a small moving business. I have no one here to bond me out. It's a moving business, and that's the only way that I can stay in my home. That's the only way I can keep my roommate in the home because she has some real bad issues with. She has a broken hip, and she's on painkillers. And I'm trying to get her into a treatment for mental illness at the Memorial over on 29th Street in Sterling and 29th. And I'm trying to, keep her healthy while trying to run a business. And like I said, I don't have anybody to bond me out here. I have a friend of mine that came here from Texas because he was having issues. He took a bus all the way down here, and right now he's just roaming the streets because he can't get in the house. Because in her mental condition, all she's doing is drinking, taking her pain pills, and laying up in the house. And if I'm sitting here, she's eventually going to lose the house. I'm going to lose the house. We're going to lose our business. That's the. And I apologize.
No, I'm with you on that. See, here's what causes me some angst. You ready for this?
Yes, sir.
You own a small moving business.
Yes, she's supposed to do.
Hang on, just listen.
Yes, sir.
So your roommate, for lack of a better term, who has all kinds of issues, is the driver of the small moving business. You're the mover.
Well, since she's broke her hip, is everything's kind of escalated.
Are you telling me you're not? She drives the van or the car or whatever it is.
She drives the car, yes. Unless she's been intoxicated or something. I mean, it's something that's been escalating since she broke her hip. And
I just didn't see that unless she's intoxicated coming.
I mean, it's like I said.
Eric, how bad's his criminal history if he has one? Hang on, just stop for a minute. Just don't say anything else, please. RR the defendant. Sir, I'm releasing you on your own recognizance. You better show up at court.
Yes, sir. Thank you.
You're welcome. Bradley Vaughn. Guy with a suspended license has a moving business. Bradley. You apparently got in a fight. Your bond's $25.
Judge, we wanted to know if you could resolve the case today.
State priors on Bradley Vaughn.
Prison for grand theft and a lot of stuff out of Polk County, from what I can tell. Most recent arrest. He had an arrest April 29th of this year for Lauderdale for possession of cannabis, drug paraphernalia, trespass. Municipal ordinances, March of this year, October of last year. Looks like battery, 2000 theft. Out of Orange County from 2015.
So Bradley seems to get in trouble about every 6 months. Give or take a little bit. If he wants to resolve it, I'm going to put him on paper.
5 days?
Judge, he wants to know if he can get a, like 5 days.
5 days in county?
I wanted to get time served. It's a disorderly conduct. So all I did was call a security guard.
How much time you got in custody?
Sir?
How much? When do you get arrested? You last night?
Yes, sir.
I'm all right with 5 days. What do you think, State?
3?
Now you're pushing it. I was going to go with 15, but you convinced me with 5. All right, hearing no objection. Mr. Vaughn, in light of your prior criminal conduct, in light of the fact that apparently, for lack of a better term, you lost control, started cursing profanities in front of a number of people, made derogatory comments about the sexuality of other people, and your extensive criminal history, I'm going to remand you to custody of Sheriff of Broward County for 5 days if you want to resolve this case. Do you still want to resolve it?
Yes, sir.
Are you on probation, parole, anything of that nature anywhere
No,
on planet
sir.
Earth? Anybody threatening or
No.
forcing you to do this?
No, sir.
You understand we could have an attorney represent you? All right? You don't want that?
Yes.
You don't want to fight this in any way?
No, sir.
All right, Bradley, how do you plead to 1 count of disorderly conduct?
Guilty.
I find you guilty. I adjudicate you guilty. I remand you to custody of Sheriff of Broward County for 5 days. Bradley, you need to knock this stuff off. Good luck. David Gershamuk.
Yes, sir.
Good morning, sir. Your bond set in the amount of $100.
No. Yes.
Judge, he wanted to know if the court would perhaps try to work this out for time served today.
Your Honor, it was trespassing. I ran across some people I haven't seen in a long time, and I overstayed my welcome at the bus station. And I came back because when the cop threw some cuffs on me, I was bleeding, and somebody said I need to call paramedics. I was looking for a phone, and that's when I got arrested.
All right, well, the police's version of the stories is you were highly intoxicated at the bus terminal.
I was drinking earlier.
Okay. I understand you want to resolve this. I'm willing to resolve this. I think one of the detriments of not having a permanent magistrate judge like we used to have is I don't know who the frequent visitors are. State, is there anything I need to know? Nothing. All right, I'll let you resolve it today, David. How do you plead?
No contest, sir.
All right, are you on probation, parole, anything like that?
No, sir.
Adjudicate time served. Good luck, young man.
Thank you.
Don't be going back to the bus terminal. Find a different. Oh, okay, well,
Not to.
apparently you didn't try quite hard enough. Don't go back.
Okay, thank you.
All right, Kenneth Clark.
He also indicated he wants to resolve this, Judge.
That's what I heard. All right, so he's got a misdemeanor for trespassing. Kenneth, what were you doing?
I was panhandling, but I haven't done that. I've been working on day labor for the last month.
Really?
I'm trying not to. Huh?
So you got out of panhandling, you're doing day labor now?
Yeah.
That's hard work, isn't it? It's safer?
Yeah, safer.
I like him. All right, I'll give you a withhold court cost. Have a good day. Bye.
No conviction on your record.
Eddie Exario. Good morning. Are we waiving formal reading on this case?
We are, Judge, but I would say that based on the language of the probable cause affidavit, it seems to be somewhat
sketchy,
especially in light of my vague recollection of constitutional law where there has to be a mention of some consideration or an amount of money or what the money's for.
Well, if you read it's not in the body, it's in the last sentence because none of that's discussed. It's just a summary versus the statements that occurred.
I still don't see where there's an agreement made here. It says the conversation ensues and becomes of a certain type of conversation. Then there's an entry into the vehicle, and then there's a takedown signal, but it doesn't say what this deal is.
Second to last sentence.
Yeah, no, his argument is,
Advising a deal had been made is not sufficient to say what that deal was for. It could have been for drugs. It could have been for something else.
there's a dollar amount right at the last there, Brian.
Am I missing something? Oh, I am missing something. Okay. I was missing that. All right. I'm sorry.
All right. Priors?
No priors, Your Honor.
I'll release him for, can you afford $200?
I don't have that right now.
Do you have, how much do you have?
I just, my friend, he's in the hotel room. I don't have that money right now.
Oh, you have no money at all? Judge, he has no money to bond out right now.
All right, his bond's still gonna be $200. If he can't post it the next day or two, we'll deal with it then. But if his only friend's in a hotel room, that's kind of a flight risk. All right, good luck.
Thank you, Judge.
Joshua Fountain.
And, can you pull out the translation?
Yeah, that's your bond out. It's gonna bond out.
Good morning, young man.
Decline the PD?
All right, Mr. Fountain, apparently on one case, you have 2 no bond warrants.
I was just wanting to know, sir. I would probably say about a year or two ago, I was taken into custody from this job that I am working at right now. And I worked very hard trying to get this job and also just to maintain some type of stability. My rent was due on the 1st of this month.
Hang on,
I do
stop. Hang on. I'm not being mean to you, just stop. I guess I am being mean. I'm not doing it to hurt you. Stay. He been in trouble in the last 2 years? I mean, if he's getting picked up on a warrant from 2 years ago, that's pretty good.
Yeah, it's, I mean, I'll check, but I mean, you can take it for the word that they are at the drug court, so.
Yeah, no, I agree with you. Sir, the state's giving me that evil eye, you know, that stink eye, because they don't want me to do what I'm about to do. You want to resolve these cases, sir?
I really need to, sir. My daughter is asking, where am I?
All right, and, well, that's a good thing, because that means you're in contact with your daughter. I'm going to ask you a question. Don't lie to me, okay? If I was to resolve these cases, it would be in the belief you haven't been in trouble in the last year and a half. Have you been in trouble in the last year and a half?
No, not that I could, no.
Not that you can recall?
No, sir.
I got to tell you, if I was in handcuffs, I'd remember it. I bet everybody else in the room remembers it. Have you been in trouble in the last 18 months?
No, sir. I haven't been to jail or anything. The only issue I have is probably with this license situation I'm trying to iron out.
Okay. Sir, you want to resolve these cases? There appear to be 2 separate cases. One's a traffic criminal and one's a couple misdemeanor counts. So apparently you have a misdemeanor for not having a proper endorsement on your license. From my experience, that means you were driving a motorcycle. All right. And then you have a possession of cannabis and a drug paraphernalia. You want to resolve all 3 of those today?
Yes, sir.
Anybody threatening or forcing you, making you do this?
No, sir.
All right. How do you plead?
No contest, sir.
All right. You understand if you're not a
Excuse me?
you understand if you're not a U.S. citizen, you're going to get deported.
Yes, sir. I just wanted to ask you, what was the consequences of the no contest?
You're not admitting it, you're not denying it, and I'm not going to adjudicate you guilty. So,
Yes, sir.
I mean, you go to Texas or Alabama or some other state, most of the states, they don't recognize a no contest. So in the eyes of that state, it's a conviction. In the eyes of the state of Florida, it's not, but it can be used against you at a later date if you pick up another criminal charge. It'll be more points in your score sheet.
I understand, sir.
You still want to resolve your case?
Yes, Yes, please. I would like to go home, sir.
All right. You understand that you don't have an attorney. There's nobody there helping you, giving you good advice, telling you what to do. You're saying you don't want any of that. You just want to be done.
Yes, sir.
Are you stipulating that there was a factual basis for this plea? Because I don't have the reports in front of me to decide it for myself. So in order for me to resolve this, you have to basically agree that there was a reason to stop you for the tag and for the dope. You don't have to admit that you're guilty, but you have to agree there was a basis to stop you and interact you. If not, you're going to stay on bond.
It was, sir.
Okay, fair enough. I'm going to give you a withhold and court costs on the TC. I'm going to give you a withhold and court cost on the paraphernalia, which is the cheaper of the two charges. I'll give you a withhold and waive on the possession of cannabis charge, and I'll give you 1 year to pay your fines.
I appreciate you, sir.
Good luck, young man. Have fun with your shop. Tyler Hand. Mr. Hand, you have a capias in the amount of $250. Good luck. Enode Duversi.
And Paul Ryan, Your Honor.
Paul Ryan.
He's a what? So I don't need to do anything on this? All right. Mr. Diversi, I'm being told by the sheriff's office that you shouldn't be here for this felony capias, that it's already been taken care of.
Thank you, Your Honor.
Good luck, young man.
Yes, sir.
Sadaki Clark. Are you Sadaki Clark, sir?
Yes, sir.
All right, sir. The state of Florida has charged you with first-degree premeditated murder. Do you understand that, sir?
Yes, sir.
Sir, I have reviewed the arrest affidavit. I have reviewed the paperwork associated with it. The arrest warrant was generated by Detective Zach Scott of the Broward Sheriff's Office. It is arguably one of the most articulated warrants I've ever seen in my life. He goes on to point out that there was video of the event as it occurred. There was video of you being present at the location, that you had discussions with multiple security guards who did positively identify you, that when they went to arrest you, that you fled, and I quote, you were running as holding on to something in your waistband. As you were running during some point in the pursuit, law enforcement came into possession of the firearm that tested positive as the firearm that killed this gentleman. And I'm going to quote from this report. This is incredible. This handgun appeared to have been dropped by Clark while he fled, as the handgun was completely dry and the surrounding environment was wet from condensation and recent rains. Sir, I do find, pursuant to Sazzy versus State, 4th District Court of Appeal, 170612, proof is evident, presumption is great. You're remanded to custody of the Sheriff of Broward County. You remain no bond, sir. You're not to be released to jail in any reason. I do find probable cause to believe that you committed first-degree premeditated murder.
In light of the fact that Mr. Clark is currently being held no bond on other charges, the defense would postpone any argument regarding proof evident presumption great at this time.
Excellent argument, counsel. Thank you. Young man, you're excused. Kyle Pelly. Mr. Pelly, good morning to you, sir.
Good morning.
I regret to inform you that on 2 separate cases, there's a no bond warrant for your arrest. You do have court on the 7th at 9 in the morning. Good luck. Michael Reed. Mr. Reed, you want a photo order on this one?
We do, Judge.
Okay.
I already drafted it, Judge. I'll be giving it to you in a moment.
All right, sir, you're charged on battery on a law enforcement officer, battery causing great bodily harm, resisting without violence, and corruption by threat of a police officer. All right, sir. According to the probable cause affidavit, while you were at the hospital or in the area of the hospital, you advised the police officer after you struck him that you were going to kill him, slit his throat, and murder him. Court does find probable cause as to that. As to the battery Leo, the court finds probable cause, prior criminal history on this defendant.
Your Honor, I'm showing that Mr. Reed currently has a warrant out of, one moment, Your Honor, out of state of Oklahoma from March 2nd of this year.
daughter in Arkansas. Need to get
Contempt of court.
I won't run. I'll come back.
Additionally,
We can hear you, Mr. Reed.
I understand that.
he was in the state of Arkansas. He was picked up 2009 failure to appear in court. 2010 failure to appear in court. That was associated with charges of aggravated assault and terroristic threatening. But it appears that those ended up being dropped, Your Honor.
So he's got a warrant out of Oklahoma?
Yes, and Your Honor, I'm sorry. He was found guilty
For driving on a
of
suspended.
the terroristic threatening out of the 2010 Arkansas case.
So he's got a warrant from Oklahoma for terroristic threatening on a case that Arkansas dropped.
The warrant is for contempt of court dealing with the shoplifting case out of
Okay.
Oklahoma.
Okay.
He also has, out of Arkansas, 2 prior arrests. There were failures to appear. He ended up pleading out to
All right, I got
terroristic
you.
threatening.
All right, as to count 1, battery on a law enforcement officer, your bond's going to be set in the amount of $2,500. As to count of battery against the alleged victim, your bond, I'm going to ROR you on that. Resisting an officer without violence, I'm going to reduce that to an ROR. Corruption by threatening a law enforcement officer, I'm going to raise your bond to $2,500, sir. So your bond's going to be $5,000. Good luck.
Judge, if I may, he indicated to me, he's from Arkansas, he indicated that he works at a vape shop, that he's never failed to appear for court before, but he cannot afford the bonds that are set. I don't know if the court would consider lowering the bond. He did ask me to ask the court for an ROR, but if the court's not inclined to do that, I would ask for the court to consider a lower bond in this case.
Your Honor, my daughter turns a year old on the 9th, and I would really like to see her first birthday.
Understand, Mr. Reed.
I generally don't ever get in trouble. This was just a stupid mistake where I was drinking and I shouldn't have been.
I wouldn't say anything else about the facts of your case, Mr. Reed.
See, Mr. Reed, I'm going to try and explain something to you, and hopefully everybody else in the room is going to be listening as well. I have 1 or 2 pages of paper to read to understand who you are. If I read the paper, which I have to take at face value and a standard is met, then I have to find probable cause that you did it. I then move on to the next phase where I decide whether or not you should get a bond, and 98% of the time I'm required to give you a bond, and you deserve one. And I have to take into consideration what the state tells me and what you tell me. So let's take into consideration what you tell me and what the state tells me. You tell me you don't get in trouble, yet the state has multiple prior acts. You tell me that you've never failed to appear in court, yet your record reflects multiple occasions where you failed to appear in court, and that the state of Oklahoma is looking to get a hold of you for contempt, which means there had to be court involved. Do you understand? I'm not asking for your opinion on that, but do you understand how that puts me in a dilemma? You can give me a thumbs up.
I understand, sir.
So basically, if I take what you said and what the government of multiple states said, one of you two is lying. And yet you want me to give you a bond and a reduction. Now, I'm going to consider the fact that you might not have understood everything that was going on, and I'm going to choose to not think that you were lying to me. But I am going to leave your bond at $5,000. Had you not had prior issues, I might have contemplated reducing your bond. But in light of your misstatements, I'm going to leave it at $5,000. Good luck. Travion Thomas. Travion Thomas.
Judge, he indicated he's going to represent himself.
All right, Mr. Thomas, you're charged with 1 count of grand theft auto and 1 count of resisting an officer without violence. Do you understand that?
Yes, sir.
As to count one, the grand theft auto, I do find probable cause. It's tenuous, but I do find probable cause. I'm going to reduce your bond in the amount to $250. Having said that, I do very strongly find probable cause that you were resisting an officer after fleeing from a vehicle that was carjacked. I'm going to raise your bond in that case to $2,500. So your bond's $2,750. Good luck, young man. Charles Carter. Mr. Carter, there's an active warrant out for your arrest. Your bond's set in the amount of $1,000. Good luck to you, young man.
Judge, he wanted to know if the court would consider an ROR on his behalf. I can tell the court that he is from Virginia. However, he has no money in the bank right now. He does have a job where he works sales.
What part of Virginia are you from?
Norfolk, Virginia Beach, Hampton Roads area.
It's also a 2009 case, Judge.
I was in the Department of Navy for a number of years.
That's where all my clients are Navy.
I didn't say I was in the Navy, sir. I said I was in the Department of the Navy.
Oh, okay. Sorry.
All right.
Judge, also, if I could just point out that this is a 2009 case.
Counsel, I got it. Where are you going to go?
I'll stay here until court's over.
State?
Your Honor, in North Carolina, twice he's been arrested on fugitive for some other states. One for grand theft out of Brevard County. That was a warrant out of Brevard County.
When?
2012. In 2014, he was arrested in Roanoke Rapids on a fugitive out-of-state warrant. In the state of Virginia.
All right, we're done. Counsel, I'd be very inclined to grant that request, but he's apparently been arrested for Florida warrants out of Florida and had to be brought back before. Your bond's $1,000. Good luck.
That's I've never been here.
Judge.
David Salvador. You gonna want a photo order on this one too?
On Carter or Salvador?
Salvador.
Yeah, it looks like it.
All right.
Morning, Judge.
Mr. Salvador, good morning to you. All right, mute that for a minute. I don't want him to say something that I think he might want to say.
No problem, Judge. Also, we would need a photo order on
Yeah, we're already getting one going for you. Apparently, during the night, last night, you were in a dispute with your roommate. At which point you called 911 and 911 and 911. I count 14 times here, but I might be a little mistaken. After the second time they came out, they told you stop calling them if it wasn't an emergency. At which point you called again demanding justice. You allegedly acknowledged you didn't have an emergency and you weren't in imminent danger. But this time you called 911 to find out what the 911 number was. You called it 130, 139, 141, 142, 204, 221, 230, 232, 245, 301, 311, and 330. And apparently after you got arrested, you asked to go to the hospital, which obviously is your right, at which point you informed the police officer that that police officer had signed his death warrant and that you were going to whip his ass. As to count one, the misuse or abuse of 911, I'm going to release you on $50 bond. On count two, the threatening to whip the cop's ass and slit his, did he say slit his throat? Oh no, death warrant and whipping his ass, your bond set at $1,000. Good luck, young man.
Judge, just so the court's aware, he indicated he has no money to afford bond. He's lived here for 42 years. He is disabled. He's on SSI.
State, priors?
I know he has some old drug paraphernalia. He's on my list. I don't know if he has anything.
Nothing recent?
20 years ago.
That being said, I still believe $1,000 bond is reasonable.
All right, let me talk to him.
Yes, Your Honor.
I want you to answer these questions yes or no. I don't need any commentary or your opinion on what happened. Do you understand that?
Yes, sir.
You understand that you're not supposed to call from this moment forward 911 unless it's an emergency.
I know that, Your Honor. I'm
Do,
sorry.
do you,
I understand.
no, just say yes or no. I don't want to go into,
Yes.
all right.
Yes.
Do you promise not to call 911 if I let you out of jail unless it's a legitimate emergency?
Yes, Your Honor.
I'm not saying you threatened these police officers or you said you were going to do anything to them, but from this moment on, do you promise if a police officer speaks to you to say yes, sir, or yes, ma'am, no, ma'am, and not have an argument with them?
Yes, Your Honor.
ROR.
Thank you, Judge.
Thank
Bye.
you, Your Honor.
Don't be coming back. Marquise Fulton. All right, Mr. Fulton, you're charged with 1 count of grand theft auto, 1 count of attaching a registration that doesn't belong on the vehicle. As a grand theft auto, I'm going to charge you $1,000 bond, or I'm going to assess a $1,000 bond. As to count 2, I'm going to release you on your own recognizance. Good luck, young man. On
Judge, you also
count
wanted to
2.
know he-
What?
He is,
They're posting the bond for you.
okay, thank you, Judge.
Emilio Cardoza. Emilio, good morning. I have the sad news or obligation to advise you, you have 2 pending open felony no bond warrants. You're going to be in court on the 8th at 8:30 in the morning. Good luck, young man. Nicholas Mancini.
Good morning, Your Honor.
Good morning, young man.
Yes, sir.
It's cold in there, isn't it?
Oh, sure.
Yeah, that's so that, they're not doing it as a terroristic sort of technique. That's so that the mold doesn't grow and the people don't get sick and ill or any of that stuff.
I understand it.
And if you need a sweater or something like that, you can have an order generated where you can get a sweater so you can stay a little warmer.
Wow.
I don't know where you're going to procure the sweater from, though. That's the second half of the dilemma. All right, sir, I regret to inform you that in 2015 or 16, I need new glasses. I can't tell which. Looks like 15, 9875 CF10A. You've been remanded no bond for a warrant. You have court on the 14th, okay?
May I ask one question, Your Honor?
You can. Just don't talk about the case.
Okay. Are there any circumstances upon which a person in my situation could be released, ROR, or pretrial release? Since I already have a bond with the judge I'm going to see in 2 weeks, I'm on probation for a misdemeanor. I committed a misdemeanor in Miami-Dade who released me on ROR.
Well, Dade County has a different way they do stuff.
Huh?
Well, Dade County's different from Broward County.
Yeah, and I have medical doctor appointments ordered by specialists for all these 2 weeks before I see the good judge in 2 weeks. That I'm on bond already.
All right, I don't want you to say anything. There's a no bond warrant because you violated the terms and conditions of your release by picking up a DUI in Aventura. Do you understand what I said?
Yes, absolutely.
All right, to answer your question, no, there's no way that I can do that. I apologize to you. It's one of the bad parts of my job, but I am deciding that you're going to stay no bond.
All right, thank you for the opportunity.
Yes, absolutely. I'll always look. Vance Rackard. Mr. Rackard, good morning to you.
Good morning, sir.
All right, sir, you're charged with a violation of parole. Do you understand that?
Yes, sir.
So let me try and, has anybody explained to you how that works?
But not initially.
Okay, so let me explain a little bit to you, okay?
Sir.
And this will make you sad because you can't hire me anymore. But I used to be the parole attorney for the Department of Corrections to represent the indigent defendant. So I kind of have a good understanding of the way this works, okay?
Okay.
Somebody from parole from DOC is going to come meet with you if they haven't already. They're going to get a whole bunch of information from you. They're going to ask you if you want representation from an attorney. At some point down the road, there'll be a hearing conducted in the jail to establish whether or not they believe you violated the terms and conditions of your parole. But you're going to sit in jail until that determination is made. You do have a right to an attorney. It just may not be forthcoming in the next day or two. Do you understand me?
I understand it.
But until you can sort this out, you're going to be held no bond, okay?
Okay.
Good luck, young man.
Thank you.
Terry Boatwright. Terry Boatwright. All right, Mr. Boatwright, your attorney called my judicial assistant and asked me to reset this until 1 o'clock or 1:30, so we're going to do that. We'll see you back at 1:30. The attorney wants to be here. Takaris Mitchell. Takaris Mitchell. Mr. Mitchell, good morning.
Good morning, Your Honor.
Unfortunately, I have the burden of giving you some bad news. There's a no bond warrant from a case that you had. I believe it's 165157 CF10A. You have court on August 9th at 8:30 in front of the division judge. Good luck to you. Erico Kyles. Erico Kyles.
Judge, he declined PD.
Mr. Kyles, good morning to you, sir.
Good morning.
All right, sir, you have a no bond warrant in case number 133735 CF10A, so you're held no bond on that. You also have a capias on a traffic offense in the amount of $500. I'm going to amend that, and I'm going to release you on your own recognizance on that traffic charge. Obviously, the felony judge will have a much better handle on what's going on with you in your life. If they choose to let you go, I'll let you go. Your status for the felony case is August 7th at 9 in the morning. Good luck to you, young man. Travis Holmes. Travis Holmes.
Can't resolve it.
All right, sir, the court does find probable causes to petty theft as to the fraudulent use of check of another. Subsequent to your arrest, cocaine and paraphernalia was found on you. I do find probable cause. Count 1, 100. Count 2, 1,000. Count 3, 1,000. Count 4, 100. Good luck, young man. Willie Daniels. Willie Daniels.
Judge, he declined PD. I don't know if you heard that or not.
All right, thank you. Good morning, Mr. Daniels.
Good morning, sir.
All right, Mr. Daniels, you have 1, 2, 3, 3 separate felony cases where you have no bond warrants. Do you understand that?
Yeah.
In addition to that, it's alleged when they brought you into the police station, they put you in one of the interview rooms, which, by the way, have cameras in them. And you allegedly, when the police walked out, proceeded to try and peel away the wall to hide some cocaine, cannabis, and other stuff. The court does find probable cause on those charges as well. Your bond on that's going to be a cumulative total of $2,100. I'm going to adopt the convenience bond. Good luck, young man. Oh, and just so you're aware, you have court on the 8th at 9 in the morning. Good luck. Dion Damone. Dion Damone. All right, sir, as to the loitering and prowling, based upon the statements of your co-defendant, I have some angst. On the loitering and prowling, I'm going to set your bond at $1,000. As to the tampering or fabricating with physical evidence, I'm going to, I'll reduce that to $100. You have a $35,000 out-of-county hold. Good luck, young man.
Your Honor,
Yes, sir.
Hang on for 1 second. State.
yes, Your Honor. Mr. Damon has a pending possession of weapon on school property.
What came first?
Yes, the charge of the possession of weapon on school property.
Was that filed?
Yes, Your Honor.
Is he on notice of that case?
Yes.
All right. What was the date that it was filed or he was served? He posted a bond when?
He posted bond February 2nd, 2016, Your Honor.
2216?
Yes.
And that case is still open?
Yes.
All right. Mr. Damon, I've just been advised that you have an open pending felony charge in Broward County, that you were bonded out on that case on February 2nd, 2016. I have grave apprehensions for the security of the residents of Broward County if you're out and about. According to your cohort, Justin, when the police talked to him, he said, no, you weren't looking for work. You were getting ready to do some burglaries. So in that case from 2016, what's that case number?
Case number is...
I'm sorry, I can't hear you.
Case number is 16-1357 CF-10A.
And I'm sorry, Judge, could you repeat it? I didn't hear it.
Yeah, it's case number 16-1357 CF-10A. Sir, I'm going to revoke your pretrial release. I'm going to remand you to the custody of the Sheriff of Broward County in light of your new subsequent charges. You're to be held no bond on the earlier case. Your bond remains the same on the other case. Good luck. Justin Knighton. Justin Knighton. Justin Knighton. Are you Mr. Knighton? What's his prior criminal history? What did I said the other one's bond for the LMP at? The one right in front of it? I don't know, the one I just... He has no record?
No priors, Your Honor.
You said Damon's bond is count 1,000 on the loitering and 100 on the tampering.
All right. Thanks a lot. Mr. Knighton, on the possession of PVP, I'm going to reduce your bond to $100. On the loitering and prowling, in light of the fact that you allegedly told law enforcement that you were there at that time in that location to do robberies, I'm going to set your bond in the amount of $1,000. Good luck, young man. Michael Ruiz. Michael Ruiz.
North Broward, Your Honor. The inmate is deaf. He's going to need a sign interpreter.
I've been in touch with the interpreter's office since this morning. They did have a sign interpreter come in at 10. He's currently in a hearing, or she is currently in a hearing. They'll be coming over here as soon as they're done.
As soon as we can get somebody, we'll do that, all right?
Yes, sir.
Thank you. Christopher Harden. Christopher Harden. Hello, Mr. Harden.
Hello. You already know. You got a private attorney. You got a...
They run out of your size shirts?
They did, apparently. It's X.
Looks like you're wearing a painting smock there.
I could parachute with it.
Yeah, probably. All right. State, in the light most favorable to the great state of Florida, he had a pipe with some drug residue in it. What's his prior criminal history?
0.
No known priors.
Are you going to stay out of trouble?
Yes.
I'm going to put him on standard pretrial. Good luck, young man.
With pretrial, he refused and signed a refusal form.
Oh, hang on. Bring him back for a minute.
Harding's little signature upon the
What's
top of
his
the
name?
page.
Yes, Your
Honor. Mr. Harding?
Are you Mr. Harding?
Yes, Your Honor.
So you have a choice to make. Either you can reconsider your position that you don't want pretrial or post a $1,000 bond. Which would you prefer?
Yeah, I'll take pretrial.
Good
Drug
thinking.
evaluation and random urine
All right, you're
analysis.
going to have to do a drug evaluation. You're going to have to submit to random urinalysis. Do you understand that?
Yes.
All right. Good luck.
Thank you, Your Honor.
Sign interpreter.
I got a
is here,
sign
Your Honor.
language interpreter here. This is North Broward, right?
Yes, Your Honor.
All right. Tell him good morning. Can he see you?
No, sir.
It might be better if you get behind the
Step
podium.
back a little bit.
Yeah, because they have another camera that comes right across there.
Can you see him there?
Yes, that's better.
All right.
I don't sign.
I don't
I
sign.
can only read lips. Okay?
I can try to be an oral interpreter for you, Judge.
We'll give it a shot.
Try to use this reading. Okay.
Michael, you're charged with possession of methamphetamine.
That is incorrect. I did not have any meth. I had paraphernalia only.
Do not discuss the facts of your case.
Do not discuss.
Okay.
You're charged with drug paraphernalia as well.
That is correct.
You also have a warrant for your arrest. Are you aware of that?
No, I did not.
He hears perfectly fine to me. Sir, can you hear me? Oh, now you can't hear me.
Okay, I can't. What did you say?
All right, sir, you're charged with a misdemeanor capias. Do you understand that? For the record, the court finds the defendant is knowing intelligently playing games with understanding whether or not he can hear me. Oh my goodness, you heard me clear as day there. Sir, I would be very careful if I was you, because I intentionally conducted my own little test when you told the translator, or I guess that the interpreter, you couldn't hear him. I intentionally put a paper over my face and said some complicated words, and you magically understood everything I said. As soon as I asked you a question in a clear and open manner, all of a sudden you couldn't hear anymore. So I am going...
Your lips. I'm not hearing you.
All right,
I'm your
so
lips.
what did I say right now? Sir, be very careful, because I just don't believe you, because I talked to you with the paper right in front of my face.
And I can understand what you're saying when I see your lips, but I did not hear you when you were behind the paper. I'm sorry.
Okay, so I guess it was random chance that you understood me. So you're charged with possession of methamphetamine. Do you understand that? Possession of drug paraphernalia and a misdemeanor capias. Your bond on count 1 is going to be set in the amount of $1,000. Your bond on count 2, I'm going to release you on your own recognizance, and you have a $500 warrant. Good luck. Court finds the defendant could hear me fine.
You getting your high blood pressure medication?
Thank you, sir.
Have a good day. Are you getting your medication?
No, I'm not.
All right, can we do something about that?
Yes, Your Honor.
All right, sir, do you have any more questions of me? Oh, I did it again, I'm sorry. I'm not used to throwing things at nice people. Not that I'm insinuating I throw things at not nice people. Good luck. Aaron Davis, Aaron Davis. Prior criminal history on him. Aaron Davis. Apparently went to the tow truck lot with a gun and got in a fight with him. Allegedly.
Your Honor, there are no known priors.
All right, sir, as to count one, I'm going to set your bond in the amount of $1,000. As to count two, I'm going to set your bond in the amount of $50. You are not to go back to that tow truck lot. Do you understand that?
Oh, they have my car. How do I get my car?
Have somebody else handle it for you. If you go back there, you're going to be in direct contempt of my order.
I won't go back.
Good luck, young man.
Appreciate it.
Patrick Jasniak. Patrick Jasniak. Court does find probable cause. The defendant was committing a burglary. Apparently, you're currently out on bond for another burglary. Is that true?
Yes, Your Honor. Mr. Jasniak was arrested a week ago on another burglary charge. He has 2 pending cases.
He has how many?
I'm sorry. 1 pending.
In addition to the other one.
In addition.
Yeah, it looks like there's a pending possession of cocaine out of Dade County as well. So, Your Honor, Mr.
Let's go back to the Broward burglary. What case number is that?
178942CF10A. And just to advise the court, Judge Zeller set a $10,000 bond on that case last week because of Mr. Jasniak's significant history, including burglary where he contemplated.
All right, Mr. Jasmick, in light of your new arrest, the court does find probable cause. On that particular burglary, last time we set a bond in the amount of $10,000. That clearly didn't work. Your bond on this new charge is $100,000. I'm also violating your pretrial release on the burglary you were picked up for last week. You're to be held no bond in that case. Good luck.
Judge, and just so I know, what is the case number on that?
178942CF10A. Court, in light of the defendant's multiple prior burglaries, in light of the fact that he picked up a burglary last week, in light of the fact that apparently was being watched by the cops as he did this, so he's risen to the level that he gets his own personal law enforcement escort because they're convinced he's a burglar. His bond's $100,000. And no bond on the other one. Miguel Lopez. I've never seen
Mr.
that
Lopez,
before.
Judge, I would be asking for a photo order.
Have you seen that before, Brian? What's that? Can I go off the record for 1 second? the record?
It's in the
Yeah.
The information that for letter receivers from Coral Springs.
Yeah.
Good morning, Your Honor.
Good morning, sir.
How you doing today?
All right, and yourself?
Could be better.
Yeah, it looks like it. Are we doing a photo order on him or no?
Drafting it right
We would
now.
ask for one, Judge.
All right. Sir, you have 4 charges against you: petty theft, possession of a controlled substance, resisting without violence, and obstructing with resisting with violence. Let me read the report. Prior criminal history on him?
I know he has a 2007 battery. 2015 theft. 2015 carrying concealed weapon. 2012 cannabis. 2011 petty theft and possession of oxycodone. 2010 theft and 2007 battery.
All right. Excuse me, Mr. Lopez, can you hear me, sir? All right,
Yes, sir, I can hear you.
I've read the reports. I do find probable cause.
Mr. Lopez did not hear the state's recitation of his prior record by the state. We don't need to go over it again, but
It won't be necessary. There's nothing in there that
Yeah.
I'm specific.
But I know
Mr.
the
Lopez,
acoustics
just
in
so
this
you're
room
aware,
are
the
not the
state told
best.
me what your other charges were. There's obviously other charges in there, but it's not going to affect my thought process. There was nothing that made me say, oh my God, I need to address this. So I would tell you what they were, but I've already kind of forgotten what they were because there wasn't really anything that made me perk up. So just hang out for a minute.
Okay.
State, talk to me about the Bat Leo charge. According to this, the defendant then grabbed my taser while flailing on the ground in an attempt to break free. What? You know, that is a good point. All right, I do find probable cause as to each of these charges. As to count 1, petty theft, I'm going to reduce your bond to $100. As to count 2, the possession of a controlled substance, I'm going to reduce your bond to $100. As to the resisting officer obstruct without violence, I'm going to leave it at $100. As to the resisting officer or obstruction with violence, I'm going to raise your bond on that count to $5,000. Good luck to you, young man. Anthony Velasquez. For the record, the court finds concerns for the safety of the residents of Broward County in light of that last probable cause affidavit, because it looks like about 9 police officers had to get there to get him under control. Responding code 3, putting all the residents of Broward County in danger. Anthony Velasquez. All right, Mr. Velasquez, I do find probable cause to the charge of sale of cannabis. Your bond set in the amount of $1,000. Thank you, young man.
Judge, would the court consider RORing him? He asked me to ask the court if the court would consider that.
I'd consider it. Why would I do it?
If I can have 1 second, Judge.
Just so the court knows, he signed saying that he would prefer to post his bond and did not want to be on pretrial supervision.
Let him know that he's told BSO he wants to pay the bond and not go on pretrial. Also, let him know we're going to drug test him every week.
Judge, after speaking with him, I believe he wants to go ahead and post bond for 1,000.
Thank you very much. Have a good day. Good luck, young man.
You too, sir.
James Hammer. Mr. Hammer, good morning.
Good morning, sir.
All right, I regret to inform you, you have a 2013 and a 2016 no bond warrant. You're going to be in court on August 14th. Good luck to you.
Thank you. That's all one case, right?
Two cases. David Love. Mr. Love, good morning to you. I regret to inform you, you have a no bond warrant out for case number 170143 AF10. That's going to be an out-of-county warrant, or maybe not. Hang on. I believe that's a Broward case because it says Robolo on it. We changed the numbering system again?
It's an arrest warrant.
Okay. Sir, it's going to be a Broward case. There's a no bond warrant out for your arrest.
You still have to make a determination.
Yeah,
Judge.
that's... Sir, what I'm doing, just so you're aware, is I'm reading the arrest warrant to see if it meets a very high legal standard. So just give me a minute, okay?
Yes, sir.
Thank you. Who's Ricky Lee Jones?
The alleged victim wasn't certain what the relationship is.
It's a very convoluted affidavit. All right. She stated the subject took the she told the subject she no longer wished to purchase the vehicle because there was a hole in the floor. She states the subject took $2,600 in cash and the title of the vehicle, which was already been signed over to her. She states the subject then got in a burgundy Nissan where the other subject was already. So show me somewhere in here, Eric, and I'm not giving you a hard time, who I can tell which is subject and which is other subject.
Your Honor, it would appear that when she identifies him, she says who is doing what. She says that Mr.
Victim positively identified David G. Love in the photo array. He was shown the third person, Ricky Lee Jones.
And she said Mr. Love was the subject who was driving the vehicle. Ricky Lee Jones was the one that put the gun to her head.
So Ricky Lee is, near as I can figure from this, the boyfriend, and David Love's the driver of the vehicle.
Getaway vehicle, yes.
So show me how we have a reason to believe proof is evident, presumption is great, that some dude who was in the driver's seat of the car knew, could have known, should have known, or was involved in an armed robbery under this standard as SAZA versus state, unless, of course, the public defender would like me to hold off on this decision and let them make the argument in the division. Hearing no response. You see what I'm saying? Because he's mentioned 2 times in this affidavit. The first time he's mentioned is the other suspect who's driving the car. And the second time is she picked him out of a lineup. I'm not saying you don't have probable cause. after she said she was going back to the house and they said they were gonna follow her because she had to get the money. I'm not saying you don't have probable cause. Tell me how I get to proof is evident, presumption is great, when nowhere in this affidavit does it indicate this gentleman ever interacted with her.
He doesn't have to as a principal.
Proof evident, presumption great.
But your question was proof evident presumption great that he interacted with her. He doesn't have to interact.
He doesn't have to interact with her. You would agree with me.
To be a principal, he doesn't have to.
You would agree with me that he didn't interact with her, at least from this report.
No, I would agree. Any getaway driver doesn't interact with the person that gets.
You're doing a great job of lawyering. I'm not interested in lawyering right now. There's no indicia that he actually participated in the robbery. He, in the light most favorable to the state, and this affidavit is the getaway driver. You would agree with me?
I can't say that because, Your Honor, under the principal theory, a principal is a participant.
Because he drove the getaway car.
In this instance, drove him there and.
How far was the getaway car from her when the robbery occurred?
Well, that's an issue of, Your Honor,
Of proof evident presumption is great.
Then, Your Honor, what I would ask is if the court is unwilling to find proof evident presumption great based on these facts, I would be asked to, I'd ask to be given 24 hours.
Granted.
Thank you.
All right, let me explain something to you, sir. Can you hear me?
Yeah, we can. Yes, we can, Judge.
All right. Under Florida law, there's a very high standard the state of Florida has to meet for me to hold you no bond. That means you just can't get out of jail. We are depriving you of your fundamental liberties as a human being. Do you understand what I just said? I read the arrest affidavit. I do see the arrest affidavit. And in reading the arrest affidavit, the only thing that I believe to possibly be accurate, and you better not say anything, all right, the only thing I possibly believe to be accurate is that you were somewhere in the area after having driven the gentleman who conducted the armed robbery. I don't know if you could see what was going on. I don't know if you knew what was going on. I don't know if you were parked around the block from what was going on. I don't know anything about that. So I'm unwilling to find proof is evident and presumption is great that you participated even in the concept of as a principal in that robbery. The state has asked for 24 hours to get a hold of somebody to do whatever they need to do to establish that they can meet that burden. I have granted that request, so you're going to remain in custody for 24 hours. Do you understand?
Yes, sir.
Good luck to you, young man. State, do you understand my angst?
You know, under that rationale, I understand that.
Generally, I have a good rationale.
The specific facts.
I'm saying, do you understand the basis of my, okay, so good luck in remedying it. Demetrius Lightfoot, and in the Office of the Public Defender, good luck in them not remedying it. Lightfoot's reset till 1:30. Timothy Kahn. Mr. Kahn, you're charged with grand theft auto, drug paraphernalia, fleeing and eluding law enforcement officer, reckless driving, and driving with a suspended license. Give me one moment, sir. All right, what's the prior criminal history on Timothy Kahn?
Your Honor, there's a 2012 leaving scene of accident and DUI.
That it?
One moment.
2011, out of St. Lucie County, possession of cocaine and fleeing law enforcement. Is that the one you told the judge about?
No.
He was sentenced to 4 years state prison.
For that fleeing and possession of cocaine?
Yes, he was released in 2015. He's got...
All right, Mr. Khan, let me review this probable cause affidavit with you. Apparently, in the city of Coral Springs, in the 4100 block of North State Road 7, it's alleged that you hopped into a 2018 RAV4 belonging to Al Hendrickson Toyota in Broward County. A short time later, members of the Coral Springs Police Department noticed a vehicle matching that description with no tag on the vehicle. They attempted to stop you. A number of officers in marked and unmarked cars, at which point you then proceeded to flee southbound on Coral Ridge Drive. You turned eastbound on 26th Court. You then proceeded to 115th Terrace and then to 30th Street. So you managed to flee, by my calculations, about 50 blocks. At the end of that 50-block pursuit, the police had apparently shut down the road. You then, in an effort to continue to get away, allegedly, drove over the curb, went around the police cars, and became intimate with a very large rock on somebody's property, at which point you were taken into custody. So the court does find probable cause for each of these charges. As to the grand theft, your bond's going to be set in the amount of $1,000. As to the drug paraphernalia, your bond's going to be set in the amount of $100. As to the fleeing and eluding law enforcement officers, your bond's going to be raised to the amount of $20,000 in light of your prior convictions and straight prison sentence for doing the same thing. Count 4, I'm going to release you on your own recognizance. Count 5, I'm going to release you on your own recognizance. Good luck, young man. All right, so what'd you hand me back hammer for? I didn't sign it? No. I'm sorry for that. All right, so we could do Lightfoot apparently? Boat right. We're not doing well at this.
They just went to get Mr. Boatwright. They had sent him back up because they thought he was reset.
This could be like the new version of Starsky and Hutch. Boatwright and Lightfoot.
Right.
All right.
He'll be down in just a minute.
And we're getting them confused. Antonio Dominguez.
He declined PD, Judge. Good morning, Your Honor.
Good morning, young man. You're charged with grand theft, illegal use of a credit card, and defrauding an innkeeper. This is a companion case, it looks like. I remember her. She was one of the first people we saw today. Do we know what bonds I set on? Let me give you her name. I want to be consistent. Natalie Bryant. So would I be consistent at 1,000, 1,025? All right, Mr. Dominguez, I've already met with your co-defendant, the young lady, earlier today. You're charged with grand theft. I'm going to make your bond $1,000. You're charged with illegal use of a credit card. I'm going to make your bond $1,000. You're charged with defrauding an innkeeper. I'm going to leave your bond at $25. Good luck, young man.
Mr. Dominguez is currently being supervised by pretrial services.
On a different case?
Case 17-2437, CF10A, 1 count of possession of marijuana. Based on this court's finding of probable cause, we ask that his pretrial status be revoked at this time.
Any argument, counsel?
He declined the public defender, Judge.
Sir, you're remanded to custody of Sheriff of Broward County, no bond for violation of your pretrial in case number 172437 CF10A. Your bonds on the current case remain the same. Wait a minute.
Okay, when is my court date for that no bond?
I just revoked it, so a court date will be generated later today or tomorrow. So I can't tell you.
Yes, sir.
All right?
Thank you.
If I could, I would. I don't know. They don't know. Preston Smith.
By the way, Mr. Boatwright's here.
Okay, outstanding. All right, prior criminal history on Preston Smith State. Good morning, Mr. Smith.
He has.
'04 violation of a domestic violence injunction, '94 burglary of a dwelling, grand theft, violation of probation, Garrett State Prison.
The main jail is telling me that they can't hear the state. I think these microphones leave a lot to be desired, but I think they need to be spoken into maybe from a little bit closer.
Mr. Smith, I'm going to set your bond at $2,000. Good luck, young man. I do find probable cause. Ronald Shepard. Mr. Shepard, you're charged with 1 count of grand theft. I take note of the fact that the vehicle that you allegedly stole was your mother's. I'm going to set your bond in the amount of $500. Good luck with your issues, young man. Douglas Silva. Mr. Silva, I do find probable cause. On count 1, I'm going to release you on your own recognizance. Count 2, that's possession of THC. Your bond set at $1,000. Count 3, I'm going to release you on your own recognizance. Emmanuel Noel.
Good morning, sir.
Judge, he declined PD.
Mr. Noel, allegedly, you went to the post office with a fraudulent driver's license. In an effort to collect 13 pounds worth of marijuana. Count 1, I do find probable cause. Your bond set in the amount of $1,000. Count 2, I do find probable cause. The bond set in the amount of $25. Count 3, in light of the unusual and strange circumstances, specifically the mail, I'm going to raise your bond to $10,000. Good luck, young man. Kadeem Johnson.
Good morning, Your Honor.
Good morning, young man. You're charged with possession of cocaine, possession of cannabis, invalid DL, expired DL, no insurance, and 2 violations of your community control on 2 separate cases. The 2 felony violations or of probation or community control, you're going to have court next Monday at 9 in the morning. Do you understand?
Yes, Your Honor. Could you tell me the cases of those 2 violations? It should be the same.
No, they're not. The first case is one. Let me tell you, okay? Give me 1 second. Thank you. Case number 125196 CF10A. 159 125198 CF10A. I apologize. It's burglary of an occupied structure. And then the other case, which was filed the same day, it looks like. So they were 2 separate cases, 2 separate events, but you took care of them at the same time. So that might be the miscommunication. Does that make sense to you?
Yes.
Okay. So you're no bond on those 2 cases. I do find probable cause. On count 1, I'm going to set your bond at $1,000. I'm going to release you on your own recognizance on all the other criminal charges, but you're going to have to address the no bond warrants. Good luck, young man.
Okay, so, Your Honor.
You go to court next week.
That's okay.
Yeah.
Thank you.
Good luck.
Okay.
Antonio Mills, Antonio Mills.
He bonded.
Johnny Collins, Johnny Collins. Good morning, sir.
Good morning.
Just ask, what was the bond originally set at? Or 10,000?
I got any paperwork on Mr. Collins?
Your Honor, this is just, it's a change of charge,
What was the bond on the other charge?
10,000.
Is it the same level charge?
I believe so, yes.
What was the other charge?
Actually, I think it's actually up file. Possession of weapon or ammunition by convicted Florida felon. This is showing this is a second-degree felony, so
What was the original charge?
possession of, hold on one moment, Judge. I'll
Hang on for 1 second, sir.
No problem.
okay, hold on, let me just,
The new charge is possession of a firearm by a convicted felon?
it's not, I know that's what it says there, but I know. I don't know why it's considered a change of charge, Your Honor. It's the same, it's possession of firearm.
What was his bond at on the other case? Or the
10,000.
other charge? All right, sir, I'm gonna leave your bond at $10,000. Good luck, young man.
All right, thanks.
Take care. All right, so did we find Boatwright?
Angel.
Mr. Boatwright, you have been very elusive to us, sir. We made a mistake. It's not your fault. All right, Mr. Boatwright, you are charged with possession of cannabis. Your bond, I find that probable cause. I'm going to make it $100. You have a no bond hold on case number 1513716, I think. Let me see if I can find it. 1513716 CF10A. There's a no bond hold on you for that. Reference to some drug that I can't pronounce. Parmaradenova-ledrophenone.
It's PVP or Flocka.
All right. So you have a no bond warrant for possession of Flocka. Do you understand what I said?
Yes.
Okay, so you're going to be in court on the 8th of next month. Good luck, or 8th of this month, I'm sorry. Didn't mean to scare you there. You'll be there in 5 days. Good luck to you, young man. Take care. That all you got?
That's it, Judge. Thank you.
We'll be back at 1:30. Court will be in recess. Thank you, everybody. Thank you, deputies.